Yes, good evening to everybody. Welcome to the today class of the JCJ second session, and hosted by the Sri Kolikonda Sharad Babu and Miss Motamari Sri Vidya today. And as per we agreed today that you are going to deal the doctrine of estoppel. Am I right?
Yes, sir.
Okay, please now switch over to the Kolikonda Sharad Babu, and once you can tell me when it is half of the time, you can deal it half of the time. Even Motamari will deal it. Is it okay?
Yes, sir.
Okay, now you can continue it.
So, in my view, estoppel means to shut the mouth, sir. And the Indian Evidence Act 1872, sections 115 to 117 deal with this estoppel, doctrine of estoppel. It is that provision which prohibits a person from contradicting himself what he has said earlier. If he says against it, then the court of law doesn't agree with it. So the doctrine of estoppel is that provision which prohibits a person from giving false evidence by preventing them from making contradicting statements in a court of law. The object of this doctrine is to avoid the commission of fraud by one person against another person. So this doctrine prevents the fraud by one person against the other person, and this holds a person accountable for false representation made by him, either through his words or through his deeds or conduct. The meaning of estoppel is, according to Section 115 of Indian Evidence Act 1872, when one person, either by his act or omission or by declaration, has made another person believe something to be true and persuaded that person to act upon it, then in no case can he or his representative deny the truth of that thing later in the suit or in the proceedings. So he cannot deny what he said earlier. So in simple words, estoppel means one cannot contradict, deny, or declare to be false the previous statements made by him in the court. So I'm giving some simple examples here. If Thanos is an employee of company XYZ, but in court, he denies to be an employee of that company. First, he says that he is employee of XYZ company, then he later denies it. Then he cannot claim the salaries and emoluments from the company later because he has already denied that he is not an employee. So he cannot claim the salaries and emoluments. Now, another example is an agent of C, mortgaged his property to B, which he was in the possession of, but was not the owner. Was in the possession, but not the owner. B, the mortgagee, thinks that the representation is true and took the mortgage. Thereafter, he obtained a decree and the property was sold. The real owner of the property is C. He claimed that it was his property and that A had no power to mortgage them. So then the court intervenes and it would stop A from making such a claim under the doctrine of estoppel. And likewise, another example is also here. M, a tenant in the house of N, falsely representing to Q that he had transferable rights over the property and thereafter transferring property to N, later on cannot claim that he had no transferable interest in the property. He would be stopped from doing so under the doctrine of estoppel. So these are some of the examples. So to explain the principles of estoppel, the following conditions are to be satisfied to apply the doctrine of estoppel. The representation must be made by one person to another person. That is the first principle condition. And the next one is the representation made must be as to facts and not as to the law. The representation must be made as to an existing fact. The representation must be made in a manner which makes the other person believe that it is true. So he must convince that the other person that it is true. The person to whom the representation is being made must act upon that belief. The person to whom the representation would be made should suffer a loss by such representation. So when he misrepresents, he should suffer also. Then only this principle of estoppel applies. This legal principle of doctrine of estoppel is viewed as a substantive rule of law, although it has been described as a principle under the Evidence Act 1872. So there are so many types of estoppel, sir. And this doctrine of estoppel has been dealt also in Code of Civil Procedure from section 11 to 40. And from section 40 to 44 of the Indian Evidence Act 1872. Some of the judgments are there, and of course, these judgments are two types: judgment in rem and judgment in personam. First of all, let us take up judgments in rem. Judgment in rem is delivered by a competent jurisdiction. This type of judgment tells about the status of the person or a thing. For example, family court dissolving or establishing a marriage, because that has competent jurisdiction, family court. Irrespective of whether the parties belong to the case or not, this judgment in rem is binding on all. So this judgment applies to the whole world. Judgment in persona. The judgments which are binding on the parties and their privies and which determines the rights of the parties to a suit or the proceedings are called judgment in persona. Do you want to add anything, sir?
Yeah, sometimes you can ask the students to read it so that we could know that they are present. Then we can give the explanation. Yes, we can ask the student, what is meant by REM? What is meant? Participants. Why? They are sleeping.
I will interfere, sir. So in REM means in the world. So throughout the world.
Decision at large.
So it applies to the whole world.
But participants are not giving the answer.
No,
Yeah, breaking of the voice is
telling you,
breaking of the
REM
voice.
means any judgment which is given at large, which is
And come to the matter of the personam is concerned.
Okay, can you hear me now?
Person.
Hello?
Yes.
Now here I am hearing you.
Yes.
Speak.
Able to hear.
Okay. Now, judgment in REM means any decision which is given at large.
Yeah, break of the voice is there. Very not. Okay. Okay, no matter. Continue.
Hello.
Yeah, break of voice is there. Very not. Very not. Mute it. Break of voice is there. Very not. Mute it. Continue, Kolikonda. Kolikonda, continue it. Sharad Babu, continue it.
Yeah.
Yes. So
Sharad Babu, I could not hear your voice. Very not. Mute.
in case
Very not. Mute.
the respective jurisdiction, yeah. Are you able to hear now, sir?
Yeah.
Okay, sir.
Yeah.
Section 44 of the Indian Evidence Act 1872 states that
Request me
in case the
to
party avoid the application of the doctrine of estoppel,
see when you read, you ask me to sir scroll it. Otherwise, people
he
will
or
look at where you are.
she can plead. Yes, yes.
Read Section 44
Okay,
of the
sir.
Indian Evidence Act.
I'm reading the kinds of judgment. Yes, Section 44 of Indian Evidence 1872 states that in case the party wants to avoid the application of the doctrine of estoppel, he or she can plead that the court delivering the judgment has no jurisdiction over the matter or that it is fraudulently doing so. The
Yeah.
party can ask the court, can plead the court that it has no jurisdiction over the matter. That is
Okay, next.
according to Section 44 of the Indian Evidence Act. Now,
Okay.
estoppel by deeds. I will go through some of the important sentences only, sir.
Yeah, but you tell me that what
It
you
is the
are saying
concept where
should be seen on the screen.
Yes, yes, sir.
Suppose if you have developed another
Now,
notes,
estoppel
you
by
have to show me. Other I can make you the host.
No, sir. It is the same thing that.
Okay, now we go to
identified.
estoppel by deed.
Estoppel by deed, it is the concept where two parties enter to an agreement by way of a deed. As to facts. This implies
Break of ice is there.
that neither he no one can
There is a break of
after
ice.
agreeing to the deed, no one is permitted to party or its representative. Now, estoppel by pious or estoppel by conduct. So scroll up, sir. Scroll up.
Did you read the estoppel by conduct? Estoppel by pious or estoppel by conduct?
Yes, sir, I am reading it, sir. The
Proceed.
elucidated
Today there is a voice break is there. I could not hear your voice.
by conduct. It has been discussed in estoppel by conduct means
Very close to your smartphone or laptop. Close to your smartphone or laptop because voice is very much low.
are you able to hear
And the
now?
break of voice.
Okay, sir, now?
Now it's very clear.
Okay, sir. Now the estoppel by deed is over estoppel by conduct. It has been discussed in already mentioned sections 115 to 117, sir. Estoppel by conduct means when a person through agreement, misrepresentation or negligence makes the other person believe in certain things upon which the other person had taken some action causing a change in their current situation, then the first person cannot deny the veracity of the statements given by him in the later stages. That is estoppel by conduct. So here is a familiar case, Sardar Chand Singh versus Commissioner Gurdwara Division. Chand Singh, the managing director of Messrs, was denied any revolver license as he was accused in a gruesome murder case and other cases. When the district magistrate issued an order that he could not hold any revolver license on the grounds of public order and safety, Chand made no appeal. This planted a reasonable belief that he has consented to it. So he has agreed to what the district magistrate has issued in the order. Later on, when he makes an application to the district magistrate to recall the claim following doctors are not considered because he has already consented to the order given by the district magistrate. So that is estoppel by conduct. Now equitable estoppel, sir. Scroll up. Equitable
Not established by election.
estoppel. Okay, this is estoppel by election. Okay. According to the doctrine of estoppel by election, the person receiving the gift or claiming the right can enjoy one of them and not both of them. That is the essence of estoppel by election, sir. For example, Kantabai offers his maid Meena Malhotra her second-hand car. Meena, out of generosity, says that she would not take it for free. Kantabai says to Meena that she has the freedom to take it as a gift or to make a payment as per her willingness. Meena has the option to either take it as a gift or claim a right over it by purchasing the car. So two options are there, either to take it as a gift or by purchasing it. Now Meena makes the payment and takes the car in her possession. After a year, Meena becomes bankrupt and asks Kantabai to return the money which she had given to her as the payment for buying the car, as she now wants it as a gift. So according to the doctrine of estoppel by election, the person receiving the gift or claiming the right can enjoy one of them and not both of them. So Meena cannot now go back upon it and take the other option. So this is the example for estoppel by elections. Now estoppel, equitable estoppel. When a person tries to take a legal action that would conflict with his previously given statements, claims, or acts, this legal principle would prohibit him from doing so. So generally, we call it estoppel in a general sense. So the plaintiff would be stopped from bringing a suit against the defendant who acted pursuant to the commands of the plaintiff. Suppose tetanus gives his gold jewelry to vaccine. So the names are
Excuse me.
very peculiar, sir. Tetanus and vaccine. Tetanus is one's name and the vaccine is another's name. Tetanus gives his gold jewelry to vaccine, the most famous jeweler in the town, for repairing. Vaccine, while handing over the jewelry to Tetanus, after repair, informed that a mark has been made by mistake at the back of the jewelry. Tetanus did not mind that and took the jewelry happily with her. Later on, if she brings a suit against vaccine, she would be stopped under the principle, as her suit would run counter to her earlier statement of forgiveness for the damage caused to her jewelry by mistakes. First of all, at the first instance, she agreed to what vaccine said, so she has taken back the tetanus, the gold jewelry. Tetanus has taken back the gold jewelry, and after that, she cannot lodge a complaint or she cannot say against anything against vaccine. Now, estoppel by negligence. This principle allows one party to claim a right over the property of another party who might not be having the possession of it. This reflects that the person being estopped owes a duty to the other person whom he had led into wrong belief. So, for example, here is a case law, sir. Mercantile Bank of India versus the State Bank of India Limited. A firm of merchants
The
committed a
Central
series
Bank of
of
India.
Yes, Central Bank of India. So it is a case between two banks. A firm of merchants committed a series of fraud and until it came to the notice of the authorities, enjoyed a high repute in the state of Madras. This firm was known for groundnuts merchant and exporters. Both the plaintiff and defendant financed the consignments of groundnuts purchased and each received a railway receipt in respect of their consignments. Later, the merchants needed a loan, so what they did was at first pledge the railway receipt from the central bank to obtain a loan and then again fraudulently pledged it to the mercantile bank also. So they pledged it to both banks. The plaintiff bank had filed a suit for conversion of the goods against mercantile bank. It was held that there was no negligence as central bank did not owe a duty to the mercantile bank, and so central bank was not estopped from having a prior title as pledges.
Give the explanation a bit.
Concept is not clear here. So next, estoppel by Benami transaction. Badrinath, the owner of land, decides to hand over the apparent ownership of his property to Kazu Rastogi. Badrinath does so and acknowledges that Kazu has paid him the consideration for the promise. Now Kazu Rastogi sells this land to Tripti Sanoon, a film actress in good faith, and for a good amount of money, as by gaining ownership over the property, Kazu has also gained the right of disposition over that property. Badrinath hates Tripti Sanoon and asserts his title over the property, but he would be stopped from doing so under the given legal principle. And this is what Benami
Yeah, which is the Benami transaction here?
transaction means. Now, estoppel on yes, sir.
Here, Badrinath made the Benami transaction or Kaju Rastogi made the Benami transaction, and what is the? Can you just explain the students? See, you said the Badrinath, the owner of the land, decides to hand over the apparent ownership of his property to Kaju Rastogi. When you say apparent ownership of his property to the Kaju Rastogi, at the time, whether Badrinath is having the title for the land. So let us see that Badrinath does so.
Kaju Rastogi is Benami.
Acha. So Badrinath does so and acknowledges that the Kaju has paid him the consideration for the promise. So now the Kaju Rastogi sells his land to the Tripti Sanoon, the film actress. So here, Rastogi is the Benami.
Oh.
And in good faith and for a good amount of money, as by gaining the ownership over the property of the Kaju, has also gained the right of disposition over the property. So here the Badrinath hates Tripti Sanoon and that is the actress and asserts his title over the property. But he would be stopped from doing so under given legal principle, and this is what Benami transaction means. That means even though Badrinath likes the Tripti Sanoon or not, doesn't matter. Because once Kaju Rastogi has given it and the Benami to the Tripti Sanoon, automatically Estoppel will work over there. At that time, Badrinath doesn't have any right to stop it. Is it clear?
It's because he has already took some consideration from Kaju Rastogi.
That means he was selling at the time.
Kaju Rastogi sold the land to Tripti Sanoon, though he is a Benami. But Badrinath, though he doesn't like Tripti Sanoon, he is estopped.
But when he wants to selling it to the Tripti Sanoon, at the time that he should stop it. But after selling it, he could not do so.
So even though he doesn't like Tripti Sanoon, that transaction cannot be denied.
But if he knows the earlier, he could stop it. Is it? Suppose he knows that He is going to sell the Tripti Saloon. At the time, say, don't sell the Tripti Saloon because I don't like to him. And at the time, can he stop the Badrinath?
Yes. Badrinath cannot stop, sir.
Even before.
If Kazu Rastogi was not his Benami, he would be having that right.
Okay.
Already he made.
So when he is paid the
made
amount, he
into
is not a
Benami.
Benami transaction.
Yes,
Okay.
is a
Now
Benami
let us go to the next
transaction.
question.
But even if Badrinath does not like, he cannot stop selling the said property to Tripti Sanu.
Okay, next. Go to the next case law.
Okay, sir, I am skipping it.
Okay, now can you hand over to the Sri Vidya? Sri Vidya is ready?
Okay, sir.
Sri Vidya, are you ready? Sri Vidya, are you ready?
She is not.
Yeah, you can continue it. Or let
Okay.
me continue it because you might have tried. Shall I continue or you can continue?
Okay, sir, you continue.
Okay. Now let us see the even at least C, she versus Pang, si, ching. Pang, si, ching. The husband here, husband died in the year 1925. I repeat, the husband died in the 1925. His entire will was made in the name of his wife. Okay. In 1930, their son, misrepresenting somebody else to be his father, bought the property of his father from the same seller who had sold the land to the father. So here, keep the mind. In 1930, their son, Hussain, deceased son, misrepresenting somebody, they represented somebody else to be his father, bought the property of his father from the same seller who sold the land to the father. Okay, let us see what is happened. Later, the grandson of the person who died rented the land to a company, and when the company stopped paying the rent, the grandson complained. The wife or the mother claimed the title over the land as her husband has made the will in her name. But it was held that the principle of estoppel by Benami transaction could be applied as she was already aware of the fraudulent selling and purchasing of land by her son. So here, a fraudulent transaction was made under the Benami. At the time, if she knows it, later on she cannot stop it. Because son himself has made such a
Yes, sir.
transaction, keeping his father as one of him, and he made such a transaction at the time, doctrine of estoppel will be worked over there. That means mother cannot stop the son's transaction, even though it is a Benami
He
transaction.
also,
Any contribution? Any contribution? Shall I proceed?
Okay,
Answer,
sir.
participants. I think participants are exhausted, it seems, because I did not
Yes,
get
yes,
the
yes.
answer.
No. Okay.
I did not get any answer from anyone except Sir Venunath. Others are silent spectators or they slept. Suresh Poonam. Sorry. Suresh Ponnam. Suresh. Suresh Ponnam. Ponnam. Are you there? Suresh Ponnam.
Yes, sir.
Say.
Yes, sir, I am there, sir.
Say present, sir.
Present, sir.
Okay. Both mentally and physically.
Yes,
Say yes.
both the ways, sir.
Okay, now you read estoppel on the point of law. Now you read estoppel on the point of law, which I highlighted on the screen and magnified
The
also.
doctrine of Estoppel does not apply to status, but only to the facts. Estoppel, if applied to the law, would go against public policy and general welfare of the society. The principle of Estoppel can be invoked for the purpose of defeating the provisions of law.
so the thing is, it does
Okay. Now I will come to the rescue.
The statutes.
Yeah.
Principle of
No, I will come to the rescue. Doesn't matter. The doctrine of estoppel does not apply to the statutes. Statutes in the sense enactments and acts, but only to the facts. For the facts only it will be applicable. Estoppel, if applied to the law, would go against the public policy and general welfare of the society. That means it will not go against the public policy, it will not go against the welfare of the society, it will not go against the statute. The principle of estoppel can never be invoked for the purpose of defeating the provision of law. For the provision of law is there, it will not go against it. So that is the example which is given in the estoppel by the point of law. For example, let me see, if a minor representing himself to a major enters into an agreement with Kanjilal for the sale of a plot of land, the agreement would be void. Reason is
it is against
agreement. A minor cannot get into agreement.
A minor cannot enter into a contract.
Yes.
And nothing would stop the minor from taking the defense that the agreement was void ab initio. It was true that at the time when he entered into the agreement, he was a minor. Suppose if anybody agreed with the minor and made a contract when he is a minor, can't the minor will take the advantage of it?
Yes.
Definitely. What is the landmark case law?
Dharmodar Ghosh.
Mohir Bibi.
Mohiri Bibi versus Dharmadas Ghosh. So, a person who enters the contract should have supposed to know whether he has the capability of entering into the contract or not. Is it or not?
Yes.
Yes. So, in Jatindra Prasad Das versus State of Orissa and others, the case law says the High Court of Orissa laid down that the estoppel cannot arise against the statutes. Again, I told you, enactments and statutory provisions. It was further said that the statutory provisions cannot be disregarded in any case, not even on the grounds of precedent nor previous administrative decision. So, a statute very, very clearly says over there. What the statute says, a minor cannot make a contract with any other person. Either the minor or the person who is the capable of it. Because the statute clearly prohibits. Kausia, do you want to say anything?
Previous judgments.
No, sir.
Sorry,
Because you are unmute. Okay. Yes,
Many precedents are there also, they are disregarded.
Yes. And let us see, this is a very much famous case law. Olga Tellis and others.
Yes.
You will refer the case law in many places. Olga Tellis and others versus Bombay Municipal Corporation and others. And this case law says, payments dwellers who migrated to India because of the proximity to their place of work started living on the payments in the Bombay. Bombay Municipal Corporation, within parenthesis BMC, initially allowed them to stay as they constituted the major part of the population of the Bombay. That means BMC allowed them to sleep on the payments. To whom? Migrated dwellers.
On the footpath.
Later on, when the payment dwellers were evacuated, Olga Tellis, a journalist, raised the questions against this action. It was upheld that no estoppel can arise against the Constitution of India or against the fundamental rights. That's the right to life and livelihood in this case. So, a journalist raised the question against this action, then estoppel can work here, there. Can the migrant people will be allowed to sleep on the payments once they allowed? Does it mean they allowed for the life?
No.
Not at all. When the constitution is changed, when the statute is changed, they are not supposed to stay or the live on the pavements. Pavement is for only
walking,
pedestrians.
Pedestrian.
So that was
तो
the
सलमान
thing.
केस हो जाएगा.
The pavement is not the resting place. The pavement is not the place to sleep. The pavement is only to walk. Even the vendors, they are not supposed to keep anything on the pavements for sell their property, so sell their goods.
Famous case. The famous case, Salman case, Salman Khan.
Yeah. Yeah, that was the case anyway, that the Salman. But I don't know what happened to the Jinka case, Jinka lady.
No,
The stag.
Jia Khan.
he escaped, sir.
Jia
He
Khan.
escaped. He was acquitted in that case.
But anyway, but we don't know, sir, because it is not
When
good to
we
comment over
have money
here.
and power in our hands.
Yeah, it is not good to comment over here. Let us go to the next, then we can stop it. Whether Srividya is present? Okay. Estoppel and tax laws. In IT Commissioner versus Films Moir, from Moir, not Film Moir, from Moir, the court upheld that doctrine of estoppel would not hold in the case where a non-taxable income under Income Tax Act has been taxed. In earlier, he was not under the taxation because it comes under the limits. Suppose if the income will be raised, can't he will be taxed? Answer is
Yes, he'll be taxed.
he will
Yes.
be taxed. At the time, he will come under the exemption. But now he doesn't come under that. Sir, last year you did not tax. How do you tax this year? The answer is your
Last year
income
the
has reached to that level. Now it can be taxable. Also, once it has been said that a tax would be collected, then one cannot give upon it. Further, stating the tax would not be collected would not be bind the state government from collecting it, as decided in the Mathura Prasad versus State of Punjab. When once the tax is made over there, but generally tax cannot be made over there unless until they will go through all the provision of it, then it will come under the taxable limits. Then only he will be taxed. Otherwise, he will not come under the purview of the taxation. Is it clear? In case
Yes,
if it is
yes.
taxed over there, let me presume it. But later on he
Refund.
can claim it. He'll come under the exemption. By
He can
showing
refund.
the-
He can ask for refund.
Yes, for refundable. For instance, you take the TDS. TDS every 3 months it will be deducted. But later on they will say, see, taxable, yeah, these are the exemption would be there. Then the amount will be refunded to you and put it in your bank. Am I right?
Yeah.
Unambiguous laws cannot be dodged. Sales tax officer versus Kanahi Lal. It was formulated that doctrine of estoppel would not arise in cases where the law clearly, without any ambiguity, states that the plaintiff should be given a relief. When it is clearly given a relief would be there, then it will not be taxed. But when he clearly made it that he will be taxed, yes, then he definitely will be taxed. When any law is absolute, has no exception clauses, then anybody acting against it would be acting beyond the powers, would be void, and the party getting affected by it can file a suit claiming estoppels against it. Whereas, if any exemption clause exists in the law, then a relaxation can be given based upon it. The party would not be said in acting ultra vires, and estoppel can be claimed as mentioned in the judgment Delhi University versus Ashok Kumar. So, when the law is very much clear that there is no ambiguity, at the time he would be taxed. No doubt at all. Earlier he may not be taxed, but later on that he will be taxed when he comes to that purview of the taxable limits. So here the principle determining there cannot be any estoppel against the statute categorized under the doctrine of estoppel cannot be applied against the state. So doctrine of estoppel cannot be against the statute. Doctrine of estoppel cannot be against the public policy, and it will be only to the facts. Is it clear?
Yes, sir.
Then here the bullet points are given. By entering into the bilateral agreement, parties can contract himself out of the statutory provisions. Yes, if the contract itself is there, out of the statutory provisions, yes, they can make it out. There must exist some provisions in the statute which prevents the parties from entering into such types of agreements which the parties would have entered into it. If the agreement is against the statute, if the agreement is against the public policy, then it cannot be made it out. The provision should be such that it satisfies the interest of the public at large. The public at large should satisfy it, not against the public policy, not against any statute prevalent or enacted at the time. The provision should not be such that only particular category of people can avail this benefit of it. No. Rule is rule, rule for all. Sir,
This is rule
then
of law.
beggars will be allowed free in the railway compartment?
No.
Yes.
No, not allowed.
Not at all. But what do you do with the beggar? He say, okay, keep in the prison, doesn't matter, because I will get at least some food over there instead of begging here. For that, no. Either you are a beggar or you are a passenger. But everybody should have to buy the ticket. Am I right?
Yes,
Yes.
yes.
So, merging of the agreement between the parties into the court's order where the parties have been discouraged from performing its obligation imposed on them by law because of certain action by the parties. So, overall, what I want to say is, you can make the agreement, but that agreement should not be against the public policy, and the agreement should not be against the law which is prevailing over there. So by saying that there can be no estoppel against the statute, it is meant that where the converse of the provision mentioned in the statute exists, the party would not estopped by his previous given statement. So once the statement is given over there, when the law clearly states that it cannot be exempted means it cannot be exempted, then estoppel will not work over there. Let us see the Jai Ram versus Srimati Lakshmi Devi. The court gave a verdict that what appears to be a law is actually a law and not is dependent on the truth of the facts and on the situation of the parties, which keeps on changing. Whether what impersonate a law is really a law, not has to be decided by the court. So, a law is a law. It is not dependent upon the facts, nor the variables. At that instance, the law would be prevail, but not the estoppel. Is it clear?
Yes, yes.
Participants, yesterday
Yes,
he went triple on the motorbike. Day before yesterday also he went triple on the motorbike. And today when he was going triple on the motorbike, the policeman caught. Can a person who went or who is riding the motorbike can say, I went yesterday, I went from the police station or from here day before yesterday, but you did not catch me. Why did you catch me today?
You
Can the
cannot
estoppel
ask.
will work over there?
No.
जिस दिन पकड़ा उसी दिन चोर है वो.
Statute says you are not supposed to go try.
Yes.
Suppose if he did not catch day before yesterday, he did not catch yesterday, but if he catch today, can you take the plea of the doctrine of estoppel?
I went yesterday without helmet, so
No.
why did you permit me yesterday?
The
Yesterday is before good.
statute clearly says there is no ambiguity in it. At that time, doctrine of estoppel could not work over there. Is it clear?
Yes.
So, all the cases here, National Oxygen Limited, Madras, Tamil Nadu Electricity Board, or any other thing, I gave a clear-cut example to you.
Estoppel cannot work against the statute.
Yes, and it cannot work against the public policy. So with this, let us stop it today's class because now the 10 time is there still, but we have taken, but our another, please, whenever the thing is there, please bring to my notice whether second session is there or not. Otherwise, our participants will be disgusted. And in any case, whether there is a thunderstorm, whether there is a whirlwind, whether there is any act of God, my class is there, it is there. Is it clear?
What about the earthquake, sir?
Act of God. Yeah, let us see that. Unless until there is a very, very, very important thing would be there, then I will at least intimate to you in advance. Today class is suspended because of this reason. Or the class will be continued after 10 minutes. Is it clear?
Yes,
The
sir.
first session will start at 8 o'clock.
Your attitude always has been impeccable, and it will continue till your last breath, I think.
Once I committed, I committed. The class is at 8 o'clock, means 8 o'clock it will be there. If it is not there, I will intimate you in advance.
आपको तो सलमान खान का डायलॉग है लगता है सर.
No, it is not there.
मैं खुद का भी नहीं सुनता हूँ कभी कभी ऐसा बोल रहे हैं आप. एक बार कर दिया तो कर दिया.
It is not like that. It is my attitude. If I could not teach, I die.
Yes, sir.
That is in your blood. That is in your blood.
Sir, once Akine Nair sir also used to say,
Yes.
that, while acting only I will die.
Yeah, because it is their attitude, it is there in their DNA. And hence, let us see the proprietor Estoppel tomorrow. And please, the other 2 minutes inform me in advance so that I can notify them and the second session is there or not. With this, I would like to stop my today's class and have a good day and bye. Sweet dreams.